morning.
Good morning, everyone. Just waiting for our fearless leader.
Morning, everyone.
Good morning, everyone. Can you guys hear me?
Yes.
we can.
All right. Sounds good. Looks like we have a forum. See council here and GM and trainer. So we will move forward. I'm going to call this February 10th, 2026 CPRB meeting to order. Thank you everyone for coming. It is 9:01 a.m. I will begin with the roll call. Start with myself, Chair Brown here, Vice Chair Mountcastle.
Here.
Member Saganovich.
Here.
Member Gatton. I see you. I didn't hear that, but I see you here.
I'm sorry, my audio was off. I don't know what you just said.
No, I was just calling your name. That's all.
Oh, here.
Yep. All right. Member Miller. Member Moore.
Here.
All right. Member Parker III.
Here.
Member Sharp.
Here.
And Member Willis.
Here.
All right. Great. So now we will move on to the approval of the minutes. First, we have the January 13th minutes, which I think we approved before. We didn't approve those. Okay. So
Yes, did. I think she just sent us the amended ones. We
yeah,
approved
she
it
sent
as
us the amended one.
minutes.
So I don't think we need to actually vote on
No,
those
we
because
don't.
we already voted pending the changes that we requested. And so I will make a note that those changes were added into the agenda. I don't know if anybody else had any concerns about the January 13th minutes. If not, we'll just move on to the next set. But does anybody have any other questions, comments, or concerns about January 13th? Okay, hearing none. I will move on to the January 27th meeting minutes, which I think is was a similar situation that we've already, because we met on the 30. Oh, okay. No. So the January 27th minutes we have not approved because our 30th meeting was really short. So does anyone have any questions, comments, concerns, adjustments that they think we need to make to the January 27th minutes before I entertain a motion on the minutes? All right, hearing none, I will entertain a motion to accept the minutes from January 27th.
I make a motion to accept the January 27 meeting minutes.
I second the motion.
Okay. All right. We have the motion has been moved and properly seconded. All those in favor say aye.
Hi.
Aye.
Aye.
Any opposed? Any abstentions?
I abstain. I was not part of that meeting.
All right. We have one abstention, and that motion carries. All right. So now we have our January 30th meeting minutes. This was an additional special meeting that we held. This meeting lasted about 5 minutes. Does anybody have any questions, comments, concerns, adjustments they'd like to make to the agenda before I entertain a motion? All right, hearing none. Would anyone like to make a motion on this?
I move that we approve the January 30th minutes.
All right, we have a motion to approve. Can I get a second?
Second that motion.
All right, seconded by Member Moore. All those in favor say aye.
Aye.
Any opposed? Any abstentions?
I abstain.
I
I
abstain.
abstain.
I abstain.
So we have several abstentions from Member Parker III, Member Gatton, and Member Sharp. That leaves us, a motion still carries. All right. So I'm assuming, sorry, I guess I kind of assume this. You guys are abstaining because you weren't at the meeting. Is that right?
Correct.
Okay. All right. We will now move on to public comment. So do we have anybody here for public comment, Administrator?
I don't believe so. We do have one person in the meeting who's just identified as call-in user 1. And if that person could identify themselves, I'm assuming that is a complainant, and we can bump your case to the front of the agenda.
All right, we have
Yeah,
a
who that
call-in
person
user.
is.
We have call-in user 1. I don't know if there's a way for them to be able to identify whether they're here for public comment or not, or just here to view. You're just here to view. That's obviously that's fine, and I don't think you have to identify yourself, but we want to allow all of our members of the public the time to speak during public comment or to speak in support of their case as well. So if you speak up now, then we can get that handled. If not, then we'll have to move forward. Okay. All right, well, then
Mr. Chair, this is Rick Myers of the Monitor team. I know my colleague Melody Stewart was going to dial in for the first hour. That may be her, but I don't know with certainty.
Okay. All right. Sounds good. Thanks for that. And welcome, Chief Meyer, thank you for attending. Again, we don't require people to identify themselves. So, hearing, nothing that they're here for specifically, we'll just move on and we will conduct business as usual. All right. So moving on, we can now move to our presentation of investigations. Do we have anyone who has identified themselves as being here as part of any of the presentations for our cases?
No, we don't have any complainants here as far as I can know.
All right, then from there we will move to our presentation of investigations, and so we can start with our table cases.
Okay. Then the first case on the agenda is for complainant Dana Watkins, case number OPS 23-0287. Investigator is Mr. Eisen.
OPS 2023-0287. The case was initially presented September 10th, 2024 by investigator Jermaine Smith on behalf of investigator Shauna Techmeyer. The case was tabled by CPRB for, quote, further investigation into what happened with the marijuana that was left behind, end quote. On December 23rd, 2023, Ms. Dana Watkins called police and told PO Josh Brogan, badge number 491, and PO Wanda Wright, badge number 2206, her 12-year-old daughter stole 2 televisions, valued at over $1,000, and exchanged it for a few ounces of weed. Both officers went upstairs to speak to the juvenile. There was no indication from the juvenile or her sister the marijuana was still in the house. The officers went back downstairs with the sister to speak with Miss Watkins. Miss Watkins never indicated to the officers marijuana was still in the house. At no point did Miss Watkins ask the officers to confiscate the marijuana. P.O. Brogan explained that in the eyes of the law, all the juvenile did was trade her own property for weed. P.O. Wright told Miss Watkins if she beat her daughter with a stick, she could end up in jail. Miss Watkins alleged a lack of service and sufficient service against both P.O. Brogan and P.O. Wright. She further alleged unprofessional conduct against P.O. Wright for saying she could go to jail. OPS recommends findings of exonerated for the allegation of lack of service, insufficient service against both P.O. Brogan and P.O. Wright, as the preponderance of the evidence supports a finding the alleged conduct did occur, but their actions were consistent with CDP Manual Rule 4.18. OPS recommends a finding of exonerated for the allegations of unprofessional conduct against P.O. Wright, as preponderance of the evidence to include the officer's WCS supports a finding that the alleged conduct occurred but was consistent with CDP Manual Rule 5.01, 5.08, 5.09. With that, I'll take your questions.
All right, thank you for the presentation. Does anyone have any questions for our investigator? Member Sharp.
Yes, investigator. Did we get an answer to the question?
They didn't. All the best I got was I do not recall. The WCS never had anybody saying the weed was still in the house, that it was anybody's possession, that it was smoke. Nobody said anything other than the TVs were exchanged for marijuana.
Okay.
Does anybody else have any other questions for our investigator? Member Skanovich.
I just have a question in general. Is there, what is the police policy if there is marijuana in the house? If there was, if somebody said it was still there, what is their policy about confiscating that type of stuff? Drugs.
The officer told me that if someone asks, like in this case, if Miss Watkins had asked them to dispose of it, they would have disposed of it. If she had just asked, what am I supposed to do with it? They would have told her, we can take it for you and dispose of it, or you can dispose of it yourself.
Just piggybacking real quick. So they're under no obligation to go searching for it?
Correct.
Okay.
Unless Miss Watkins had specifically said, I think it's still somewhere in the house. Can you look for it? They're under no obligation.
I want to make a note of this situation, if I could, Chair.
Yeah.
Investigator, you said in the report that the police told them that I might be getting this wrong. It was kind of no crime committed because the child was exchanging their own merchandise for the marijuana, correct?
In the eyes of the law, yes, that's what Officer Brogan told Miss Watkins.
But when I grew up, nothing in my house belonged to me, and my mother made that clear. So technically, she gave away somebody else's TV. And I mean, I know I'm splitting hairs here, but that's just kind of how I see it. Those weren't her TVs to give away, so I don't know if the officers really did the right thing by telling her that. That's all.
Which was Miss Watkins' point, and P.O. Wright had offered to call DH on speaker for Miss Watkins to see about taking her daughter down to DH, but Miss Watkins declined the offer.
So it sounds like. Go ahead, Member Sharp.
Yeah, I'm sorry. I'm following up on Member Willis's question. So I kind of don't get it then. If what did she expect to happen if she didn't want the daughter to go to DH, and no demand to search for the weed? I'm kind of confused.
I'm not entirely sure. She did go the next morning to speak with detectives to file unruly on her daughter. P.O. Wright had told her that if you start filing unruly, eventually DH will take her.
But again, then they're under no obligation to then go back and pick the daughter up. So she came down to the station, filed unruly, or wherever she went to file unruly. They're under no obligation to go back and pick the young lady up, correct?
Not unless they're instructed to, no.
Okay. All right.
Yeah, and looking back through, looking specifically at the language that we have for the complaint, um, I'm looking at the final approved report we have. Ms. Watkins said her daughter stole some property, said the officers did not ask about the marijuana or confiscate it. She said she took the marijuana and flushed it. She said she told them she had the marijuana but did not ask them to take it from her. She said officers told her that if she used physical discipline against her daughter, they would arrest her. And then she said a male officer told her that marijuana is legal. So, I mean, based on that kind of basis of her complaint, um, if she didn't ask the officers to confiscate the marijuana, and then she also, when the officers asked about, holding her daughter accountable through contacting DH and she declined that, it seems like maybe her issue is that the officers weren't more vigilant about the marijuana in the house, but it doesn't seem like she prompted that in the moment from them. So I too am a little bit. Well, I'm definitely not. I'm actually not confused. It seems like she was upset by the interaction, but I'm not sure that the officers here committed any sort of violations. But Member Saganovich.
So I think the issue with DH was the DH won't take kids who are just unruly. They have some standards, and I think that's what they were explaining to her, and that's why they said they would call DH so she could hear it from them that, for an unruly charge, even with a simple assault, I don't think they were taking them at that time. I remember from the video and the officer's interaction. So I think that was more the issue than them not wanting to do something for her. And they did the best they could. They've referred it on to a detective. They did a report. They've referred it on to a detective, and they told her that she could talk to somebody about it.
Member Gadden.
I don't know that it changes how I would vote on this, but I have questions and concerns, I guess, regarding the law, and maybe it's just my own ignorance. I understand that marijuana laws have become more lax or liberal or whatever word you might want to use around that. But if the facts that the officers are believing are that a 12-year-old bought marijuana, I'm pretty sure marijuana laws don't allow that. And I don't know what the amount you're allowed to even possess is anymore. So, and it seems like they're saying, hey, there's nothing against the law here. It blows my mind if the marijuana laws are so lax that they say, yeah, kids can buy it now, it's fine. That's just not, I gotta believe that's not the law.
Right. Yeah. I agree that that's definitely not the case.
Yeah, so I don't understand that their kind of whole attitude was, she took your TV, she traded them. I'm not using the proper tone there, but it seems like they're looking at saying they took your TVs. It's your kid. She bought marijuana. In fact, officer says, there's no laws were broken here. That doesn't seem accurate to me. And again, I don't know if, I didn't think I could go out and buy 2 ounces or trade for 2 ounces of marijuana today. I don't know the laws. It just seems like I thought there were more restrictions on it than that. And certainly there are more restrictions on it for children. So to just say, hey, no laws were broken here. Your 12-year-old went out and bought some marijuana and brought it home, 2 ounces. It just, something's not right there.
Well, and I think in that case, going back to Member Saganovich's point about them opening up a case with a detective and kind of forwarding this on to another department, I think part of the issue is that when they're in the moment and they're at the complainant's home, I think it's not that there's generally no illegal activity that happened, because I would imagine that selling marijuana to a minor is certainly an offense of some sort, but those offending people aren't there. And so it's about the person who traded the TV is the minor child. And so they were trying to do something about that or figure out, okay, these are options there. They discussed that with the complainant about what those options would be as far as with the minor who was present, who was involved. And then I think for the other people who were involved, whoever accepted this TV and traded the drugs, that would be more so handled by the detectives when this case was kind of passed on. So I think in that moment, it's not necessarily that nothing happened or that there were no violations there, but I don't know that there was much they could do as far as a juvenile in that moment without more prompting of some sort by the complainant. And it seems like, yeah, the complainant went down and did some more follow-up on this the next day. Member Sharp.
Yeah, one more question for the investigator, because I do have concerns with officers' actions on the scene. So, investigator, when did she indicate she flushed the marijuana down the toilet? Because if no marijuana was on the scene when they got there, I think there really wasn't much that they could do.
She did not. She never said anything about flushing it down the toilet on their WCS.
Okay, but then I guess when she was interviewed, she said she flushed it down the toilet.
Correct.
And we don't know if that happened before officers got there or while they were there or after they left.
Correct.
Yeah, I not having seen the marijuana themselves, I don't know. Yeah, I really kind of don't know what they could have done in regards to an arrest. All right, thank you.
Okay. Any other questions, comments, concerns, thoughts? I also want to note for the record that Member Miller is here. All right. Hearing no other discussion, would anyone like to make a motion or motions? If you could, officers here. Well, yeah. All right. Hearing none, I will make some motions. All right. In case number 20, in OPS case number 2023-0287 for Officer Wanda Wright, badge number 2206, for allegation A, lack of service, insufficient service, an alleged violation manual rule 4.18 and 5.01. I move for a finding of exonerated as the preponderance of the evidence, including WC interviews, WCS footage, written reports, all support that the alleged conduct did occur, in that the officers did show up, and they didn't take anyone into custody. They also did not search the home for marijuana, but that the conduct was carried out in alignment with the standards outlined in the applicable GPOs and manual rules, since communication was made with the complainant about her options in this situation, given that the claimant's child was a minor, and that the other parties who were involved in the sale were not present. So again, this is a motion for exonerated.
Second.
Seconded by Member Sharp. All those in favor say aye. Aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, same case. This is 2023-0287. This is for allegation B. It's allegation B of unprofessional behavior, unprofessional conduct, for Officer Wanda Wright, badge number 2206. And badge number 2206 in alleged violation of Manual Rule 5.01, 5.8, and 5.09. I move for a finding of exonerated as the preponderance of the evidence, including interviews, WCS footage, and written reports, supports that the alleged conduct did occur, in that the officers for the same rationale that I've already stated. I don't want to go through it again. For the same rationale that I already stated, that the officer's conduct was still in alignment with applicable GPOs and manual rules.
Second.
All right, seconded by Member Sharp. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, same case, 2023-0287. This is for Officer Joshua Brogan, badge number 491, regarding allegation C, insufficient service, an alleged violation of Manual Rule 4.18 and 5.01. I move for a finding of exonerated as the preponderance of the evidence gathered throughout the investigation supports a finding that the alleged conduct did occur, but that the officer's actions were consistent with the relevant manual rules. Again, my motion is for exonerated.
Second.
Seconded by Member Sharp. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right. And
Just a quick note, Chair, on the agenda.
Yep.
Allegation D, we have Officer Wright's name and badge number there, but that should be Officer
Brogan.
So the last two should both be Officer Brogan.
Right. Okay. And I could have, I probably could have lumped those together too, but it threw me off too when I was reading the agenda. But I did catch that in the report. Thank you. Okay, so last one, case 2023-0287. This is also for Officer Joshua Brogan, badge number 491. This is for allegation D of unprofessional behavior, conduct in alleged violation of Manual Rule 5.01, 5.08, and 5.09. I move for a finding of exonerated as the preponderance of the evidence gathered throughout the investigation supports a finding that the alleged conduct did occur, but that the officer's actions were consistent with the relevant manual rules, specifically the facts here that P.O. Brogan explained the options available to the complainant, and he explained why, in the eyes of the law, that complainant's daughter would not be considered stealing. Also, WCS footage never picked up Officer Brogan saying that marijuana was legal. So again, my motion is for exonerated.
Second.
Seconded by Member Sharp. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. All right, and I think that's it for that case. We don't have any more tabled cases for today. We don't have any IA involved cases, so we can move on to our new cases for today.
Okay, so the first new case is OPS 23-182. The complainant's name is Lamar Edwards. It's also Investigator Eisen.
OPS 2023-0182. On July 26, 2023, Mr. Lamar Edwards filed a complaint alleging unprofessional conduct by Detective Samuel Pelsnick, who has since separated from CDP, a lack of service against Detective Michael Dunn, badge number 269, and an improper procedure arrest against Detective James Howard, badge number 921. His complaint alleged he was cooperative in attempting to purchase 3 firearms, but was unsuccessful and still charged. His complaint was filed 2 years after the initial incident, exceeding the 6-month statute of limitations in the collective bargaining agreement. On June 24th, 2021, Mr. Edwards was arrested in a gun sweep. He spoke to Detective Pelsnick about becoming a confidential informant. Mr. Edwards did have a firearm in his possession at the time of his arrest and had been previously convicted of multiple felonies, including multiple convictions of having weapons under disability. Detective Howard arrested and conveyed Mr. Edwards to the Cuyahoga County Jail around 1:45 a.m. on June 24th, 2021. Later that same night, around 11 p.m., Detective Dunn told Mr. Edwards that he would be held in abeyance, explained what abeyance meant, and that if the info he provided to officers panned out and helped them get something else, the charges would be dismissed. Detective Dunn also said that if a dead end, he could always be indicted later. Mr. Edwards said he understood. Detective Dunn said they wanted someone who has multiple guns, is selling guns for a living, possibly has a house full of guns. Detectives Dunn and Howard both told OPS no promises were made about being a CI. The blank CI packet used by CDP is 2 pages long and says in part, quote, "The purpose of this agreement is to allow me the opportunity to assist the Cleveland Division of Police with criminal investigations. The prosecutor may then consider the nature and extent of my assistance, which may result in a reduction of criminal charges. I fully understand that other than advising the appropriate prosecutor of the nature and extent of my cooperation, the Cleveland Division of Police cannot and is not promising me any awards, payments, immunity from prosecution, or other compensation in exchange for my cooperation." Detective Howard said he witnessed Mr. Edwards sign this agreement, which would have been signed by the vice sergeant, who at the time was Sergeant Kaufman, who has since separated from CDP. Detective Howard was unsure of how long that paperwork is kept for. OPS is administratively dismissing Allegation A, unprofessional conduct against Detective Pelsnick under OPS Manual Rule 703A, non-CDP employee. OPS recommends a finding of exonerated for Detective Howard for Allegation B, improper procedure arrest, as the preponderance of the evidence supports a finding the alleged conduct of arresting Mr. Edwards by Detective Howard did occur, but was consistent with CDP Manual Rule 4.18. OPS recommends a finding of exonerated for Allegation C, lack of service for Detective Dunn, as the preponderance of the evidence, to include Detective Dunn's interview with Mr. Edwards, supports finding that the alleged conduct did occur but was consistent with CDP Manual Rule 5.01. And with that, I will take your questions.
All right, thank you for that presentation. Does anyone have a question? Member Sharp?
Yeah, I have a couple. Investigator, what happened to the original form that the complainant signed to become a CI?
So Sergeant Kaufman, who was the vice sergeant at the time, would have held on to it, and then it was secured. But the officers, the 2 detectives that I interviewed, had no idea how long that was kept for or where it would even be at this point.
I can't say that that's a good practice. That should be in a system somewhere, an electronic system somewhere, a copy or a document of that magnitude. Secondly, Mr. Edwards was under the impression that he was to help lead detective to, according to your statement, other people who were selling guns, correct?
Correct.
So that would not provide him to personally have guns on his person. Correct.
He was initially arrested with a firearm, and then after he was
Mhm.
arrested was when they had the conversation about him becoming a CI.
Okay. And that sort of didn't pan out, I assume.
Correct.
Okay. Thank you.
All right, does anyone else have any questions, comments, concerns? Member Gatton? No? Okay. I do think that this is at least some example for any members of the public who are watching about. I think this is a good time to kind of talk a little bit about the processes of how being a confidential informant works. I don't know all of the details of any of the programs, but I do think it's worth noting that, our prosecutors and our police officers, while they do obviously work together, they're not in charge of the same things. Officers are not in charge of ultimately what people get indicted for and how charges are carried out throughout our legal system. And so officers, to Investigator Eisen's point, officers don't really have the authority to, present immunity or guarantee that you won't be charged for something. And the language of our confidential informant packets state that. This is also a reminder that to make sure that you're clear on what you're doing and what you're signing and what everything means before you read it and sign. I mean, before you sign it and go forth with it. I imagine this complainant may have been under the false pretext that that he was gonna not be arrested or receive some sort of immunity or things like that. But based on what we're seeing here, it doesn't seem like there's any sort of evidence that was promised to him. So just be careful out there. All right. Anybody else have any other questions, comments, concerns, statements before we make some motions? All right. Hearing none, would anyone like to make any motions?
Yeah, I can make some motions.
Okay, sounds good.
All right. Case number 2023-0182. Allegation A, unprofessional behavior conduct. I'm making a note that that allegation against Detective Plechnik, badge number 1885, it was administratively dismissed. All right. Same case, 2023-0182, allegation B, improper arrest against Detective Howard, badge number 921. My recommendation is for exonerated based on the preponderance of the evidence in that the action did occur, but was in line with Manual Rule 4.18. My recommendation is for exonerated.
Second.
All right, that motion for exonerated has been seconded by Member Gatton. All those in favor say aye.
Aye.
Any opposed? Any abstentions?
I'm going to abstain. I have trouble viewing the video on this case. I couldn't get them open.
All right, we have one abstention from Member Saganovich. And that motion carries.
All right. Same case, 2023-0182. Allegation C, lack of service, insufficient service against Detective Dunn, badge number 269. My motion is for exonerated based on the preponderance of the evidence in that the action did occur. But the detective was in accordance with Manual Rule 5.01. My recommendation is for exonerated.
Second.
All right, we have a motion that has been seconded by Member Gatton for exonerated. All those in favor say aye.
Aye.
Any opposed? Any abstentions?
I abstain, same reason.
All right, one abstention. That motion carries. Oh, that's it. We can move on to the next case.
All right, the next case is OPS 24-068. Complainant's name is Sierra Giles, and the investigator is Mr. Eisen.
OPS 2024-0068. This report was completed by Investigator Landman. On March 23rd, 2024, the complainant, Ms. Sierra Giles, received a ticket for being double parked in front of Insomnia Cookies from PO Lizette Lopez, badge number 1968. Ms. Giles alleged unprofessional conduct behavior by P.O. Lopez, saying P.O. Lopez told her, quote, "Since you want to talk shit, I can give you a ticket," and threw the citation at her. P.O. Lopez's WCS does not capture anything until she's behind Mrs. Giles's car, taking down her license plate number. P.O. Lopez then hands Mrs. Giles the citation, as Mrs. Giles says, "I hope that camera is on," simultaneously taking the citation from P.O. Lopez and tossing it on her dashboard. There is no video of P.O. Lopez sounding an air horn or talking to Mrs. Giles about moving her vehicle, as the complaint alleges. Statements from both Mrs. Giles and Officer Lopez contradict each other, though Mrs. Giles' wife's statement supports Mrs. Giles. Additionally, there was a city power outage that night, meaning street cameras were unable to record. OPS recommends a finding of insufficient evidence for the allegation of unprofessional conduct behavior as the preponderance of the evidence fails to establish whether the alleged conduct occurred or if it is consistent with CDP Manual Rule 5.01. On August 30th, 2024, an addendum was added due to the board's request. OPS asked why P.O. Lopez entered G1101 as her badge number on the citation, and was that within WCS policy. CDP Mobile Support Unit said, quote, All officers have a LERMS number in addition to a badge number. The LERMS number is used to enter tickets and as a secondary identifier. Badge numbers can expire due to it being issued to another person. For example, if a person resigns or is terminated. Badge numbers are recycled and LERMS numbers are not, end quote. With that, I'll take your questions.
Okay, any questions for our investigator? We've reviewed this case before, right? I see on the addendum, it says that this case was presented to the board back in June of 2024. Is that right? Or am I in the wrong case?
Yeah,
I think you're correct. I recall this case. I don't
Yeah.
remember the date.
did we table it wanting to know about the badge, or did we rule on other aspects of it?
I think we tabled it because of the badge.
Yeah.
Yeah. But I also thought of another question here. Is there a WCS violation here because she didn't turn it on right away?
I was thinking that too, because it seems like there's a lot of interaction that occurred before the WCS is turned on. There's clearly something, like there was clearly an interaction between the officer and the complainant before the WCS is turned on. At least it seems that way to me.
It seems like there's two interactions with the complainant before the WCS is turned on. One was ask her to move, and then the other one was when they came, I think she came back. I don't think it was one interaction. I think she drove away and then came back, the officer, if my recollection is correct.
Investigator Eisen, did we ask the officer about, I know you said that we have conflicting statements from the officers. Between the officer and the complainant. What was the reasoning that the officer gave not having the WCS on before? Did we ask about that before this moment? Why she didn't turn it on before the moment that we get?
One second. Let me get the accurate statement for you. So in her interview, Officer Lopez said she saw Mrs. Giles' car double parked in the middle of traffic lane, went behind the vehicle and alerted her with an air horn as a signal to move her car. Officer Lopez then said Mrs. Giles only moved a few feet forward, continued to block traffic, and other cars still had to maneuver around her. She said that when she sometimes signals with the air horn for drivers to move their car, the driver may not be paying attention. She would then pull beside the driver and ask them to move their car, then go on her way. She said that she pulled up to Mrs. Giles' car, asked her to move and park along the curb lane. And she believed that Mrs. Giles told her something about the parking situation. She then left to attend to other vehicles, and she saw that Mrs. Giles had not moved her car, so she backed up the patrol car, pulled beside her again, and asked her to move her car. She said she did not remember exactly what was said, but her demeanor appeared to be, Mrs. Giles appeared to be agitated and was talking in a raised voice. She said she knew she needed to keep traffic flowing and told Mrs. Giles that being double parked was a, quote, ticketable offense. She said she went to hand Mrs. Giles a citation, and she believed she heard Mrs. Giles saying something about her WCS camera and recording. She said the camera was on, but Mrs. Giles did not respond. That's everything she said in her interview.
So she didn't turn it on right away when she knew that the woman was somewhat, when she came back to her, when she was going to have a second interaction. And this is
Right,
sort
when
of
I
like our
s- when
Lyft
I-
driver the last time.
When I saw the initial part of the video, something's going on, they're conversing, but the audio is not picking up on the camera.
Because she didn't turn it on yet. That's that 30-second back,
Right.
right? Yeah.
Well, I
Well,
believe
so
so.
that means she didn't hit the button until they were already talking. Because again, from the moment she hits the button, the audio starts. It back records 30 seconds. It locks the 30 seconds from before you hit the button with no audio. But from the moment you hit the button, the audio starts. So because usually the first thing we hear is the officer hitting the button. So I mean, I guess for our determination is, should she have hit the button before she walked up to the vehicle or before she approached the complainant? Or does it seem more like once she, which is admittedly how I'm leaning, that once she kind of realized, okay, this is getting to be a contentious situation, I'm going to turn my body cam on now in the middle of the discussion. I don't know if anybody has any thoughts on that. Member Willis?
Thanks, Chair. Yeah, in my opinion, anytime they have an interaction, before they have verbal interaction, period, whether they think it's going to be good, bad, or indifference, they should have the camera on, in my opinion.
So, in accordance with GPO 4.08.04, I think is the GPO. I'm trying to go from memory on that. The language it essentially states that if they believe the confrontation may turn, what's the word that they use? It's like if the interaction may turn
Confrontational.
Confrontational.
I think that's the language.
Member Sharp?
Yeah, so I was going to say, as you were saying that, Chair, obviously, as we've discussed in many cases, giving someone a command inherently can potentially turn confrontational. So I agree with my colleagues that the camera should have went on at the first interaction, because at the first interaction, she was telling her to move her car. That's a command.
Any other thoughts? I'm pulling up that exact language again. It is it's generally pretty broad language.
Yeah, but I'm thinking, Chair, maybe as you are, that this may be one where we add the WCS charge to what we have already.
Chair?
Oh, sorry, I can't see hands. Member Saganovich?
Yeah. I'm not so sure that the first interaction where she blew the air horn and told her to move the first time, I'm not so sure she really needed the WCS. But as soon as she was backing up to talk to her again, she should have known that that's very likely to become some kind of confrontational or kind of discussion that wouldn't go well if you've got to come back to somebody. And at that point, she should have turned it on before she even opened her mouth with when she drove back.
We have these WCS situations often, and this is one. If you're doing parking patrol, or I don't know what they call it, traffic control, you know that her job almost all night is driving around the crowded areas, telling people move, can't park there, quit standing in the street. They're basically giving commands all night long. And every one of them, I mean, if you give a command to any citizen, it can become adversarial or confrontational, whatever that exact language is.
It's adversarial. I just looked it up. It's may or become adversarial.
Yeah. So, do we expect that every time she's about to tell somebody, hey, quit standing in the street, that she's got to hit it? Because anytime you give a citizen a command, it can become adversarial. They could say, screw you. So she just keep it on all night. So I don't know. There's just times that there's kind of a reasonableness. Like, is she every single time she's going to say anything to anybody that's double parked or standing there with their car door open or, dropping somebody off and, waiting too long or not moving in traffic, or every time she's going to talk to a citizen, that would require her to hit it, because what she's about to say could become adversarial. Even if she is going to say, excuse me, sir, I know you might be waiting for somebody here, but can you step back up on the sidewalk, please? that can become adversarial. So, you know, is that what I understand the GPO? And, you know, obviously there's always, you know, the letter of the regulation and you know, is that what we're charged with assessing? Or is there reasonableness that we could take a look at and say, you know, second time around, she hit it, albeit late. I don't know. It's just always, it's just, you know, they can't be Nostradamus and know exactly how every single interaction is going to be. If we want to start ringing them up for all of these, then, you know, anytime you're going to talk to a citizen, you better turn it on, because there are people out there that are going to make any discussion with a police officer, no matter how kind and professional the officer is, they can make it adversarial. So we could jump to, hey, you knew you're going to talk to somebody. That can become adversarial. So
Yeah.
you know,
So
I tend to lean. You know, I wouldn't lean toward creating this charge, because I don't think it's reasonable that every, you know, especially in that job, that every single time she's going to talk to somebody, she's got to hit the camera. Every single time. Every time she's rolling down her window to say something to somebody, she's going to have to hit it. I don't. That's my 2 cents.
Yeah, I mean, I'll jump in. I'll see you, Member Sharp. I'll say that I think it is very much part of our job to make reasonable interpretations of these rules that are put in front of us, right, when we are electing to enforce them. And so I you know, if we are choosing that, you know, there needs to be some sort of reasonableness standard here, I don't think that is outside of the purview of what the letter of the GPO says. I also think there may be, if we haven't already, an opportunity for us to send this over to the CPC and ask them to, you know, clarify this language, because it is extremely broad to just say may become adversarial. Because, Member Gatton, to your point, that's a pretty low bar, which I think is partially the point. Lean on the side of turning your camera on more than not. But obviously this has put us in a pickle a couple times. And I do think that I'm leaning towards maybe not sustaining a WCS finding here. I think it may be different from, say, did last meeting, where there was a situation where there was an officer who was clearly made a situation, or essentially was antagonizing a complainant that they already identified as being agitated, as opposed to just continuing the duties of carrying out their duties as an officer, which is what happened here. As far as writing the ticket, Member Sharp.
Yeah, I just want to elaborate on what Member Gatton said just a bit. So I do agree, but as I stated before, in knowing that you're going to give a command, that reasonably can turn into a combative situation. Now, just simply saying hello to somebody, I don't think you should turn your WCS on for that. Now, even that could, but reasonably you wouldn't think that it would. But giving somebody a command where you're going to ask them to do something, I think a reasonable person could think in this particular job that could turn adversarial. That's my 2 cents. Sorry.
Member Shiganovich.
I know we're kind of beating horse here. I agree with, in part with Member Gatton, in that I don't think they have to turn it on every single time they talk to somebody. My point here is that she drove away and she came back. That's when she should have known that this may become adversarial, because she's going to be telling this woman in this car to do it again. And to me, that's what should have tipped her off. And she should have turned it on sooner. She eventually turned it on, but she should have turned it on sooner.
Member Gatton.
My last 2 cents. I think that if we get prickly about these situations of, you know, should they have turned it on 20 seconds sooner, you know, a minute sooner, 10 seconds sooner, ultimately, if what it could lead to is, if I were this officer, or we can expect that officers might just say, you know what, I hit the WCS. I hit it 20 seconds late. The review board, sustained an allegation that OPS didn't even start with. And you know what? When I start my shift, I'm going to turn my camera on. It's going to be on for the next 8 to 12 hours. I'm not going to play that game, especially in this job, because anybody that I'm seeing, I'm telling them, hey, move along. So do I need to sit there and just keep hitting it all night? And if I don't do it one time, am I going to be disciplined for it? So I think we get to a point where if we say you need to follow the letter of the GPO, or we'll sustain a charge against you. I think that's a potentially expected end to how officers' behavior might change.
Yeah, so I'll jump in just to say I think regardless of how we interpret this case and ultimately this GPO, I don't think we'd be going outside of the letter of the GPO, because we shouldn't be doing that. But I do think there's some kind of vagueness here that allows room for our interpretation of how to apply it. And I think that's kind of where we are with it. We've been discussing this for a while, so I will say, I'll ask, does anybody else have any thoughts that they want to have, any final thoughts before we start to make any motions, particularly anybody who hasn't said anything yet? If anybody has any thoughts they'd like to put forward, please feel free to do that now. Okay, hearing none, would anyone like to make motions?
I'll make a motion.
All right.
Okay, in case number 2024-068, allegation A, unprofessional behavior with P.O. Lopez, badge number 1968, regarding manual rule 5.09. I make a motion that we go with insufficient evidence, because based on the preponderance of the lack of evidence, I think that this is a fair ruling regarding the situation.
All right, we have a motion on the floor for insufficient evidence. Can we get a second?
I second the motion.
I second.
Seconded by Member Moore. All those in favor say aye.
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 Any opposed? Abstentions? All right, that motion carries. Member Willis, you want to make any other motions on that? You don't have to, but I know we were discussing the WCS, so I don't know if anybody wants to make a WCS violation motion. It's not on our agenda. We don't necessarily have to. But
I did not. I
Okay.
I agree with Member Gatton, to be completely honest with you.
Okay. Due to the discussion, I will open it up to the other board members if anybody else would like to make a motion regarding a WCS violation here. Okay. Well, you know what? I'm gonna make a motion on this, just so we have something on the record, beyond just our discussion. That kind of, because that kind of says where we are with this. So I am gonna make a motion on OPS case number 2024-0068 for Officer Lisette Lopez, badge number 1968, for an added allegation of, we'll call it allegation B, for a WCS violation, in alleged violation of Manual Rule 4.06.04. And I move for a finding of exonerated as the as the preponderance of the evidence, including interviews and written reports and WCS footage, shows that the alleged conduct did occur, in that the officer did turn on their body cam after a certain amount of interaction, but that the conduct was carried out still in alignment with the GPOs, particularly because the officer did turn on the camera during the interaction once the interaction became adversarial in the eyes of the officer. So again, my motion is for unallotted.
Chair, I am going to second that motion on the sake of consistency. So I appreciate you offering that motion up. I second.
All right, we have a second from Member Sharp. Any discussion? No. Okay. All those in favor say aye.
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 Any opposed?
Aye.
All right, we have one opposed from Member Sharp. And any do you want to provide a rationale? You don't have to.
Yeah, I can. Because like I said, in the past, we've said if something we perceive that can become adversarial, I do believe in giving somebody the command, you can predict that may become adversarial, and to the manual at that point it should come on. So I'm making my my vote along those lines. I want us to be consistent.
All right. So we have one opposed. Any abstentions? All right, that motion carries. Have we? This is a question for all of the board members. Have we sent over anything to the CPC asking for clarity or asking for them to review the WCS GPO? I feel like we have, because we've had this discussion multiple times. Jaleesa, I see you have your hand raised. I'll tag you in on this.
Yes, we have sent over 2 letters to the CPC. We just have not got a response regarding the WCS and its vagueness, whether, adding things and also just trying to get more clarity on that. But we just have not received a response back from the CPC as of yet. I can follow up on that today.
Yeah, if you could follow up just to see, where they are with, reviewing the GPO, because this is something, this is one of the GPOs that we are often interpreting, and we often find ourselves running into just interpretation issues. And we can keep interpreting it as we see fit. That's part of our job. But I think it's important that when we see a consistent issue with a particular rule, that we look at maybe getting it adjusted, maybe asking for some clarity, maybe just asking for more specific language. But I guess we will have the record reflect that we have inquired to this CPC about this twice now. So I won't make a motion that we necessarily do that again. But if you could follow up, that'd be great. Thank you. Okay. With that, we are ready to move on to the next case. Moving at a brisk pace here.
Okay, next case is OPS 24-097. Complainant's name is Christian Lansky, and this is Investigator Oak.
Good morning, everybody. Can you guys hear me?
Yes, you're coming in a little low.
Morning.
All right, this is OPS case 2024-0097 with the complainant, Mr. Christian Lansky. Subject officer is Kirsten Berengel, badge 691. So OPS received a complaint from Mr. Christian Lansky alleging lack of service, insufficient service against Patrol Officer Kirsten Berengel for an incident that occurred on April 20th, 2024. Mr. Lansky alleged that P.O. Berengel downplayed an incident in which a security guard was threatening him while defending the suspect's actions and not completing a report with all of the suspect's information. OPS found during the investigation that P.O. Berengel spoke with both involved parties, gathered their statements, and created a report. In the original report, P.O. Berengel did not add the suspect's name and information. However, she and her partner did create a follow-up supplemental report 4 days after the incident, which included the suspect's information. The investigation found that P.O. Berengel abided by CDP Manual of Rules 3.12 and 4.18. And then with that, based on the investigation of the citizen complaint, OPS recommends allegation A, lack of service, insufficient service against P.O. Kristen Berengel, badge 691, be exonerated. as the preponderance of the evidence gathered throughout the investigation supports the finding that the alleged conduct did occur, but the officer's actions were consistent with law, CDP General Police Orders, and Manual of Rules 3.12 and 4.18. And with that, I'll take any questions.
All right, thank you for that presentation. Anybody have any questions for Investigator Oak? Member
do.
Sinanovich?
Talking a lot today. Investigator Oak, did the officer ever ask the suspect whether or not he used his taser in any way? Because the video that she was shown, you could hear the taser cycle in that video. Did she talk to him about that?
I'm not sure if she talked with the suspect, but I believe it was just the complainant about the taser. But I don't think it was brought up with that. Her partner did speak as well. There's two WCSs of both of them being there. So yeah, I don't believe Berenguel spoke with him directly about the taser.
Okay. Did anybody ask her about that in the interview? I don't remember that part.
She was not interviewed. No, this was an abridged case.
Okay. That's why we didn't have an interview of her. Okay. Because I was curious as to why she didn't follow up on that piece.
All right, any other questions for our investigator? Any other question, comments, concerns, statements? All right, does anyone, would anyone like to make any motions?
I'll make a motion.
All right, thank you.
In case number 2024-0097 regarding police officer Kirsten Berenguel, badge number 691, regarding the lack of service, insufficient service. My motion is to exonerate based on the preponderance of the evidence, including the WCS, and the follow-up of the amendment to the original report. She did investigate, she did file a report, and she did do an amendment of the report to include the suspect, which is consistent with Manual Rule 3.12 and 4.18.
Second.
All right, that motion has been seconded by Member Gatton. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. Right. I think that was it for that case.
Okay, the next case is OPS 24-131. Complainant is Natasha Miller. Investigator James Oak.
Again, this is OPS case 2024-0131. The complainant Ms. Natasha Miller. Subject officer is Patrol Officer Jordan Tipton, badge 1591. On June 9th, 2024, OPS received a complaint from Ms. Natasha Miller against Jordan Tipton, alleging biased policing, improper procedure arrest, and unprofessional behavior. Ms. Miller alleges P.O. Tipton handcuffed and placed her brother in the police car for no reason and was disrespectful. Ms. Miller feels she was discriminated against and that the officer would not let her speak. The OPS investigation found that Ms. Miller's brother, Mr. Bright, was arrested due to threatening to shoot his neighbor. P.O. Tipton spoke with all parties and had probable cause to make an arrest after a witness and victim both corroborated that the threat was made. WCS footage is indicative of no unprofessional behavior or biased policing taking place. P.O. Tipton remained courteous and respectful in his interactions with all involved. P.O. Tipton was in compliance with Manual of Rules 3.12 and GPO 1.0708 outlining bias-free policing, Manual of Rules 5.09 on behavior, and GPO 2.0201 investigatory stops when detaining and arresting Mr. Bright. And with that, based on the investigation of the citizen's complaint, OPS recommends a finding for allegation A, bias policing against Jordan Tipton, badge 1591, be unfounded. as the preponderance of evidence to include the officer's WCS supports a finding that the alleged conduct did not occur. The officer's behavior and actions were consistent with Manual Rules 3.12 and GPO 1.0708. Secondly, allegation B, unprofessional behavior. OPS recommends a finding of unfounded as the preponderance of evidence to include the officer's WCS supports a finding that the alleged conduct did not occur. The officer's actions were consistent with Manual Rules 5.09. And then lastly, allegation C, improper procedure arrest. OPS recommends a finding of exonerated as the preponderance of the evidence gathered throughout the investigation supports a finding that the alleged conduct did occur, but the officer's actions were consistent with law, CDP general police orders, training and procedures, which included GPO 2.0201 investigatory stops. And with that, I'll take any questions.
All right. Thank you for that presentation. Does anyone have any questions for our investigator? Okay, hearing none. Does anybody have any thoughts, questions, comments, concerns about anything with this case?
Yes, hello.
Hello? Is this?
Yes, am I able to make a comment because this is what I've been sitting on the line for like an hour for my brother. This is Miller.
Okay, yeah, one second. Yes. So we at the beginning of the meeting, I was trying to figure out who you were, so that way we would have moved this case up so you wouldn't have had to wait an hour.
Right. I explained that I was here for the case, but neither here or there. I do want to be able to give my side of the story. I'm just been listening, and it seems like you guys are saying that you don't find any findings, like it was not true what happened. So I want to be able to give my opinion about what I feel was unjust for my family and my brother.
Sure.
Am I able to go ahead and?
Okay. Yeah. So you will absolutely have the opportunity to speak to the board and basically give us any information or perspective that you'd like to provide for us to consider in ruling on this case. So I don't know if we had some audio issues earlier, so we didn't hear you when you came in and stated that you were here for this case. Otherwise, we would have moved it to the front. So I apologize for you waiting that long. That certainly wasn't our intent. We usually move the cases for people who are here to the front, but we didn't see that come in. We had you as and your name wasn't present until just now. It was and it's just call user number 1. So so with that being said,
okay.
Give me 1 second. All right, so yeah, so you will be afforded 4 minutes for you to pretty much discuss anything that you'd like for the board to consider when it comes to determining the outcome of this case. And when you have about 1 minute left, I'll try to flash something to let you know that you have about a minute left. From there, if the board has any questions for you, we will ask any follow-up questions. Once that portion has concluded, we will move on to continuing with any deliberation that we may have on the case. And then from there, we will move forward with our ruling and go on from there. So with that, I will start your time and you can begin when ready.
Okay, yes. I just wanted to state that when the officer came out, to me it appeared that he knew the neighbor. I don't even really know the neighbor, but it seems like he spent a good chunk of time over her at her residence. He was playing with the kids. He was playing with the dog. He was just talking to her. So then when it came time for him to come over to our side and get our point, I was totally dismissed. He actually said, "Get back. Why are you telling somebody to get back? I didn't have anything to do with the incident. I wasn't able to say anything." He told me, he's taking my brother. I felt like everything was unjust because the bottom line is that my brother was a victim. His vehicle got hit. We went to the 4th district. The officer there said it was considered a hit and run. This officer did not write it up as a hit and run, but it was a hit and run because if you hit somebody's vehicle, the people across the street never said anything. It was another neighbor that seen it on the ring light camera that notified us and told us like, hey, this person hit the vehicle. As far as them arresting him, my brother was not out of conduct. He was actually peaceful, cooperative. Everybody on our side was cooperative. They simply detained him because of his prior record, which is not right and it's unjust. I don't understand how a person gets their vehicle hit and then now they're arrested. And I do feel like the lady, if she definitely told a lie, because if he actually would have did what she claimed he did, he would be locked up right now. So I feel like he had to spend money for an attorney. She didn't come to not one hearing, no court hearing. She wasn't present on none of that stuff. And then the person that she lived with, if her boyfriend, even after all this time done elapsed, my brother is at my residence, he tried to speak to them. Or somebody tried to threaten to kill your girlfriend, why would you be speaking to them and saying hi and what's up? It makes no sense. So I feel like it was unjust, very discriminatory and just. I felt like he never should have got arrested. And then to make matters worse, he had some swelling in his foot and ankles, and he had that ankle bracelet on for like all that time. He was like downtown in the county jail. I had to go through a lot to like try to get in contact with his doctor to try to get them to take that off. He's also a caregiver for my elderly parents. So that whole situation caused a lot of stress for everybody involved. And I just feel like it was just wrong because that officer didn't give nobody on our end the opportunity to say anything. It's just, okay, you got a previous record. Let me just go ahead and detain you. That lady lied. And what is the accountability on that person end? Because as I stated, if it was true what she said, he wouldn't be free right now. He would be locked up if a person threatened to take somebody's life. That never happened. The person didn't want to take accountability for damaging somebody's property, and he was victimized by them and the system because he never should have got detained. He never should have had to spend not a day in jail. Should have never had to pay no money. The whole family was under a mass amount of stress. It created a lot of stress for me. I had to still go to work, still take care of my parents, do all the outside work at home, just everything. And then my thing is, these people still live across the street from me, and I just feel like it should be some kind of justice on his end, because what if something happened down the line? Like if a person just tell a lie and then now somebody's life is, they're sitting up in jail somewhere based off of somebody telling a lie. And I do feel like the officer knew that lady, because if you're coming out to investigate and see what's going on, why are you playing with a dog, and why are you playing with a kid, and why are you just like over there? Because I'm sitting there watching the whole thing. Why are you sitting there giving this person that if you don't know them, why are you just hanging out like this is a friend or something? And then when it comes to us, I'm, being cordial, trying to like figure out what's going on, and I'm getting dismissed and saying, get back. And he treated me like I done did something, so the whole situation was just not right. So I just feel like it was just unfair to my brother, my family, just detaining somebody just because they have a previous record. So you just assume this person is a dangerous person and just threatening somebody because of something that you run his information and you see that he had previous felonies. That's irrelevant. He didn't do anything wrong. He was the victim. They damaged his property, and it made no sense that he got arrested after somebody damaged his property. And they were acting a fool when they came outside, creating all the
Ms.
chaos.
Miller, I'm gonna jump in because we're about a minute over. So I'm gonna jump in. So I'll jump in just to ask board members, do you have any questions? And thank you, Ms. Miller, for that statement and providing that context. It is certainly helpful in us viewing this case and determining particularly whether or not how we're going to move forward on this. Do any board members have any questions for Ms. Miller? No questions. Anybody have any questions, thoughts, comments on based on the statement, based on what we have reviewed already? including the body camera footage that we have here, or the report that was made by or presented by Investigator Oak. Sorry, I can't. Member Sharp?
Yeah, Investigator Oak, on the bias policing, based on Ms. Miller's comment, was there any indication that you found that the officer knew the people across the street previously?
No, sir. There's no evidence.
Member
Thank
Saganovich.
I just want to thank Ms. Miller for coming. I know this is a very tough situation for her, and clarify that our role is really whether or not the police followed police policy, procedures, and training. We do not determine whether or not the underlying case that went to court. We don't have anything to do with that. We just have to do with the officer's actions. So I just want to clarify that in case you missed, because I think sometimes citizens come here and they think we can do something about what happened in court. We can't. We can only look at the officer's behavior at the time and whether it was consistent with police policy, procedure, and training. But I thank her very much for coming.
Yeah, and thank you, Member Saganovich, for that context. It seems like there were some issues beyond just the arrest that was made, and some of the what went further beyond this, ankle monitors, and I do think that it's important that we don't just gloss over how all these interactions can affect members of the public, and how often these seemingly, it may seem small interactions, can really upend the lives of citizens. And that's whether the officer performs things the correct way or not. Either way, I mean, they can have tremendous ramifications here. Another thing I do want to bring up, Investigator Oak, I know that this is an abridged report, because the WCS footage pretty much shows all of the officers' conduct during this time period. So we didn't, we haven't interviewed the officer or anything to specifically ask, did you know anybody before you showed up? We don't have that, do we?
No interview was conducted. There's no indication during the interactions with the neighbor that they knew each other. Officer Tipton was, trying to diffuse a escalating situation, keep the peace of what he could manage. So yeah, I reviewed the WCS footage, our investigative assistants reviewed the WCS footage, and there's no indication that he knew the neighbor.
Yeah, and I think also when you look at the footage, you can see that it was a chaotic kind of situation, based on what happened. Tempers were rising, tempers were flaring. The officer did an investigation on the scene, which is him interviewing interviewing all the witnesses involved, or everyone involved. He got corroborating stories from two of the neighbors, which I understand. Obviously, they're both the neighbors, and I get that. But it is the officer's job to kind of weigh the evidence in the moment to determine aggressor, and determine, if there needs to be an arrest made. And, we've spoken in the past about us trying to put ourselves in the mind of the officer at the time, which can be dangerous, without some sort of clear issue that we see with the officer's evaluation, right? So if there were people that the officer just straight up didn't talk to in order to get the picture, right? So Ms. Miller talked about how the officer asked her to stand. I think part of that is because of we had a pretty chaotic situation that the officer's trying to get under control. So, but I can understand how it is frustrating, and there's a lot going on in the moment. Does anyone else have any other statements or comments they want to make? Okay, with that, does anyone want to make any motions on the case? Okay, hearing none, I will make some motions. All right, in case number 2024-0131 for Officer Jordan Tipton, badge number 1591, for bias policing, an alleged violation of Manual Rules 3.12 and GPO 1.07.08. I move for a finding of unfounded as the preponderance of the evidence, including WCS footage and interviews, as well as written reports, establishes that the alleged conduct did not occur. Specifically, there was nothing on review of the field footage that showed that the officer made any sort of biased remarks based on any sort of protected class, or even just bias from the general sense of the word toward any particular party. But in fact, the officer interviewed multiple parties and made a determination based on his interviews. So again, my motion is for unfounded.
I second that motion.
All right, it's been seconded by Member Moore. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. Same case 2024-0131 for allegation B of unprofessional behavior, unprofessional conduct. Again, as it relates to Jordan, PL Tipton badge number 1591. I move for a finding of unfounded as a preponderance of the evidence, including WCS footage, interviews, and reports, establishes that the alleged conduct did not occur.
Second.
Seconded by Member Gatton. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. Same case, 2024-0131 for Officer Jordan Tipton, badge number 1591, regarding allegation C for an improper procedure, improper arrest under GPO 2.02.01. I move for a finding of exonerated as the alleged conduct, and that the arrest was made, and that the officer did speak with multiple parties, including the neighbors of the complainant. But however, the conduct was carried out in alignment with the standards outlined in the applicable GPOs and manual rules. So again, my motion is for exonerated.
Second.
Seconded by Member Sharp. All those in favor say aye. Aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, that was everything for that case. I think the complainant was dropped off the call. But nonetheless, we appreciate all complainants who come before us. And even though in this case, we ultimately ruled, we didn't rule any sustained findings, we still want people to engage with our process because it allows us the opportunity to hear the perspectives of our citizens as well. So with that, we will move forward with the next case.
Okay, the next case is OPS 24-151. Complainant's name is Lana Henderson Austin. This is also Investigator Oak.
All right, last one for me. This is OPS case 2024-0151 with the complainant Ms. Lana Henderson Austin. Subject officers are Patrol Officer Anthony Robertson, badge 1322, Sheldon Brown, badge 1514, Angelo Lucarelli, badge 529, Joseph Russo, badge 231, Nathaniel Ellis, badge 1524, and Detective Paul Benedictus, badge 303. So on July 8th, 2024, OPS received a complaint from Ms. Lana Henderson Austin alleging lack of service and biased policing against members of CDP. Ms. Henderson Austin stated that she contacted police on multiple occasions regarding disputes with her neighbor involving threats, trash can altercations, and alleged property damage. She alleged that officers refused to arrest her neighbors because two of them work for the city. Then on July 10th, 2024, OPS conducted an in-person interview with Ms. Henderson Austin. She stated that each time she contacted police, she was advised to follow up with the prosecutor's office. She reported that when she attempted to file charges, the prosecutor informed her that the incidents did not meet the elements required for prosecution. She further stated that if she were white, action would have been taken. OPS reviewed 3 CDP reports dated June 26th, 27th, and 28th of 2024. documenting separate disputes between Ms. Henderson Austin and her neighbor. OPS also conducted a video recorded interview with officers Anthony Robertson and Sheldon Brown, who responded to one of the incidents and provided clarification regarding the actions taken. So after reviewing all evidence, including complainant statements, officer interview, and crime reports, it was found that officers provided service and abided by CDP Manual of Rules 4.18 and did not have implicit bias and abided by GPO 1.0 or 1.0.08. And then with that, OPS recommends allegation A, lack of service against patrol officers Anthony Robertson, Sheldon Brown, Angelo Lucarelli, Joseph Russo, Nathaniel Ellis, and Paul Benedictus be exonerated as the preponderance of evidence gathered throughout the investigation, to include WCS, incident reports, and interviews, supports a finding that the alleged conduct did occur, as no arrests were made, but the officers' actions were consistent with Manual of Rules 4.18, duty to investigate. And then lastly, OPS recommends a finding of unfounded for allegation B, bias policing against patrol officers Anthony Robertson, Sheldon Brown, Angelo Lucarelli, Joseph Russo, Nathaniel Ellis, and Paul Benedictus, as the preponderance of evidence gathered throughout the investigation, to include WCS, incident reports, and interviews, all support a finding that the alleged conduct did not occur, and the officers' actions were consistent with GPO 1.07.08. And with that, I'll take any questions.
All right, thank you for that presentation. Does anyone have any questions for our investigator? All right, seeing none. Does anyone want to make any motions?
Chair, I can make the motions.
All right, thanks, Member Sharp.
All right. Case number 2024-0151. Allegation A, lack of service. I'm going to lump these together. So against Detective Benedictus, badge number 303. P.O. Brown, badge number 1514. P.O. Ellis, badge number 1524. And P.O. Gotta spell this out. Lucarelli. Relli, badge number 52529. P.O. Robertson, badge number 1332, and P.O. Russo, badge number 231. My recommendation is for exonerated based on the preponderance of evidence, given that the action did occur, but the officers and detectives were in accordance with Manual 4.18. My recommendation is for exonerated.
All right, we have a motion for exonerated.
Second.
Seconded by Member Saganovich. All those in favor say aye.
Aye.
Opposed? Any abstentions? That motion carries.
All right, same case, 2024-0151. Allegation B, bias policing against Detective Benedictus, badge number 303. P.O. Brown, badge number 1514. P.O. Ellis, badge number 1524. P.O. Lucarelli, badge number 529. P.O. Robertson, badge number 1332, and P.O. Russo, badge number 231. My recommendation is for unfounded based on the preponderance of the evidence and the investigator's report, and that the officers were in accordance with Manual Rule 4.18. My recommendation is for unfounded. That's what I said.
Friendly
Right,
amendment?
Yep.
Friendly
Yes,
amendment?
please.
But they were
Yeah.
consistent with GPO 1.07.08, the bias policing GPO.
Got you. I'm sorry. You're absolutely right. Thank
Will you
you.
accept that?
I accept your friendly amendment.
Thank you.
All right, we have a motion on.
Then I'll second it. Can I second it after doing an amendment?
I think you can do that. I don't think it's a problem. It's still his motion. So, so it's been seconded by Member Saganovich. Again, this is a motion for unfounded. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries.
I think that's it, Chair.
Yep. All right. So,
Thank you.
Thank you. So now we will move on to our final case.
Okay, this is OPS case 24-270. Complainant's name is Sierra Summers, and the investigator is our general manager, Jessica Watson.
Okay, as stated, this is OPS case 2024-0270. Complainant Sierra Summers. Our officers are PO Joshua Howe, badge 1190. PO Russell May, badge 2129. PO Logan Weber, badge 2425. And Sergeant Kevin Walker, badge 9234. On August 24th, 2024, Sierra Summers was sitting in her inoperable vehicle on the side of the road with her two small children and seemingly intoxicated per a witness nearby who noticed her stumbling and smelled alcohol on her breath. 5 officers responded to the scene to include PO Howe, Weber, May, and Sergeant Walker. Ms. Summers refused to open her window to identify herself, and so her passenger window was broken by PO Weber in order to gain access to her vehicle, inside of her vehicle, and her two small children, who were later determined to be endangered. Ms. Summers was removed from her vehicle, arrested, and transported to Cleveland Clinic due to her being physically and verbally combative. Ms. Summers alleges excessive force against PO Howe, May, and Weber when she was pulled out of her vehicle and fell onto the ground, then placed into the zone car. She also alleges excessive force when she was removed from the zone car and placed on the gurney at Cleveland Clinic. She alleges excessive force specifically against PO Weber for hurting her arm while she was cuffed to the hospital bed at Cleveland Clinic. She also alleges property damage by PO Weber when he broke her passenger side window to gain entry into her vehicle. She alleges improper arrest by the officers, claiming that she was not driving intoxicated, though she was found guilty of having physical control of a vehicle while under the influence on December 4th, 2024. She also alleges unprofessional behavior in how the officers spoke to her throughout the evening. OPS determined that the arrest and property damage were both justified and that PO Howe and PO May were professional in their conduct with Ms. Summers. However, OPS also finds that PO Weber was unprofessional in his speech toward Ms. Summers at the hospital while she was in physical restraints and in the process of being sedated, when he stated, "You put your mouth near me again, you're going to get hit." This verbal threat of an already combative and restrained Ms. Summers visibly upset her and escalated the situation for everyone in the hospital room, which is a direct violation of Manual Rules 508 and 509. OPS also finds that excessive force was used by PO Weber at the hospital when Ms. Summers was already handcuffed. He held her arm in an awkward position while she yelled, "Look how this expletive is bending my arm." 4 days later, Ms. Summers reported pain and bruising on her left arm to her doctor. This is a level 2 use of force per GPO 2.01.05. He also failed to report this to Sergeant Walker, which is in violation of Manual Rule 4.05, equating to an additional allegation of improper procedure, failure to report. Sergeant Walker was a supervisor at the car and later in the hospital, but he was not present when PO Weber was assisting with the restraints at the hospital. He would have only been required to review WCS if a use of force report was filed by PO Weber. Based on the preponderance of evidence to include WCS interviews, and incident reports. OPS recommends a finding of exonerated for allegation A, excessive force against P.O. Joshua Howe and P.O. Russell May. OPS recommends a finding of sustained for allegation A, excessive force against P.O. Logan Weber. OPS recommends a finding of exonerated for allegation B, improper procedure arrest against P.O. Joshua Howe, P.O. Russell May, and P.O. Logan Weber. OPS recommends a finding of unfounded for allegation C, unprofessional behavior conduct against P.O. Joshua Howe and P.O. Russell May. OPS recommends a finding of sustained for allegation C, unprofessional behavior against P.O. Logan Weber. OPS recommends a finding of exonerated for allegation D, property damage against P.O. Logan Weber. OPS recommends a finding of exonerated for allegation E, improper procedure against Sergeant Kevin Walker. And OPS wrote an addendum on February 2nd, 2026, adding an additional allegation F for improper procedure, failure to report against P.O. Logan Weber, citing GPO 2.01.05, and recommends a finding of sustained for this allegation. I will take any questions.
All right. Thank you for that report. Thank you for that presentation, rather. Does anyone have any questions for our general manager? All right. Does anyone have any questions, comments, concerns, thoughts? I guess I'll throw out there to confirm. I mean, this, just so we're clear, the sustained recommendation is from behavior that occurred at the hospital after all of these arrests were made, not the original arrest that required, the breaking of the window and pulling out the car and all that stuff. All of that has been recommended to be determined as essentially de minimis force that was necessary in order to effectuate the arrest. But we have the conduct of this officer kind of after the fact, on a restrained civilian who was being combative, is particularly verbally combative. So this officer decided that he was going to enact some force and kind of pushing her into some awkward positions with her arm and of the such. Member Sharp.
Yeah, Investigator Watson, the incident in the hospital with P.O. Weber, as the complainant was restrained, I think, by hand. What was going on as he made the comment, if you put your mouth near me, you'll get punched in the face? I mean, she's clearly restrained, so what could have been happening there?
She was leaning upwards and kind of like yelling at him and doing that. And then she specifically said,
yeah, I have it. Well, she says, I see so you about to punch me. If you put your mouth near me again, I will. Then she says, expletive. What you mean? Then he says, you put your mouth near me again, you're going to get hit. And then at that point, Weber pushes her like forehead back down to like lay her back down. Mind you, this is after he'd already leaned her back before and held her down via I'm looking at the written transcript right now. Via her collarbone, kind of push her down this way. And so there were two other officers who were there in the room that were also holding her down. But I think the specific one, she's already in restraints, but two, I think the specific issue is him kind of grabbing her by the forehead and pushing her down. And also, I mean, the manners that he's trying to restrain her. I think just are what's excessive here.
Yeah. Yeah. I agree. All right. Thank you, Investigator Watson.
Any other thoughts, questions, comments? Member Gatton?
After deliberation and voting, I just want to have an observation, perhaps discussion, and maybe motion regarding breaking the car windows.
Okay. Anybody else have any questions, comments, concerns, thoughts on this? Okay. Then with that, would anyone like to make any motions? Okay, I will make some motions. One second. I want to make sure I have my language in front of me. Okay. All right. In OPS case number 2024-0270 for officer, actually we'll do these at the same time for two of these officers. For officers, Joshua Howe, badge number 1190, and Officer Russell May, badge number 2129, regarding allegation A of excessive an alleged violation of Manual Rule 4.05, as well as GPO 2.01.01. I move for a finding of exonerated as the preponderance of the evidence, including interviews, WCS footage, and written reports, supports that the alleged conduct did occur, in that the officers did break a window to get the complainant out of the vehicle, as well as they did drag her out of the vehicle and arrest her. So force was used, but that force was minimal in relation to what was required in order to arrest or detain and arrest the complainant. And so therefore, the conduct was carried out in alignment with the standards within our GPOs and manual rules. So again, my motion is for exonerated.
I second that motion.
All right, seconded by Member Moore. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right. Same case, 2024-0270. This is for Officer Logan Weber, badge number 2425. This is also regarding allegation A for excessive force and alleged violation of Manual Rule 4.05 and GPO 2.01.01. I move for a finding of sustained as the preponderance of the evidence, including interviews, WCS footage, and written report, supports that the alleged conduct did occur and was inconsistent with the division standards in violation of Manual Rule 4.05 and GPO 2.01.01. Specifically, the officer's conduct when at the hospital with the complainant was inappropriate, particularly in the instance where the officer pushed complainant's forehead down in order to attempt to lay the complainant back down while the complainant was being restrained by other officers. This was in response to a verbal back and forth in which complainant stated to the officer, quote, "So you about to punch me?" End quote. The officer responded, quote, "If you put your mouth near me again, I will." End quote. In which then there was another back and forth. Be what you mean. Then the officer says, "You put your mouth near me again, you're going to get hit." And that's when the officer made contact with the complainant's forehead and forcefully pushed her down. This was inappropriate and inconsistent with our manual rules in GPOs. And so with that, my motion is for a sustained finding.
I
Can I add
second that
something?
motion.
Could I add something to your motion?
Sure.
That he specifically held down her arm in an awkward position while she was handcuffed to the bed and she complained how it hurt.
Yes.
That was part of why
Yeah,
it's
thank you.
sustained.
Yeah. So, and also including the that the officer was holding her arm as well into an clearly uncomfortable position that was and he was notified of this by the complainant based on her own complaints, including language that specifically states, "Look how this N-word is bending my arm," referring to how the officer had her left arm in an awkward position. So thank you for that. Yeah, I'll add that to the motion as well.
I second that motion.
All right, and Member Moore seconds that motion. So again, this motion is for a sustained finding. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, we will need a group level. Actually have my disciplinary guidance ready to go this time.
I think Member Gatton has a question.
Oh, okay. Sorry, you guys are.
Well, I was just going to group level. Excessive force is always a group level 3, unless
All right.
for some reason would want to determine at a lower level, which would be having to use something like other similar misconduct. But group level 3, excessive force, physical force not within policy. That's the only group level that excessive force falls under.
All right. Yep, I see that here. Does anyone have any other thoughts on that, or any reason why they would advocate for a group level 1 or 2 here? All right, hearing none.
Actually, I will.
I'm sorry, Member Sinanovich.
I would advocate for maybe a group level 2. It was excessive force, but it wasn't any kind of permanent injury. It wasn't kind of shooting somebody, killing somebody. It wasn't anything that was so egregious that I think the person has any kind of permanent damage. So I would put it under other similar misconduct on violation 2. Maybe, I don't know if there's one we could use in there. I don't know how other people feel about that. Dave?
Member Gatton? Yep.
Yeah, I would oppose that. Certainly it doesn't rise to the level of a beating or a shooting or something like that. But we have a person that's restrained. There are other officers there. There's really very little reason to be putting hands on the person at this point. So while I concur, yeah, this wasn't a, permanent injury situation. Once somebody is in restraints, there's very few reasons why an officer needs to be using any level of anything but the minimus force to guide them, put them into the back of the car or whatever. The complainant provided at that point no risk to the officers, and it was just unnecessary. That's how I view it.
Chair, I'd just like to go on record as concurring with Member Gatton. I think certainly we have to go with a group level 3.
I think you've convinced me, guys.
Yeah. I mean, same. I mean, I kind of remember Sinanovich. I actually had similar thoughts to you when I was just reading through the. Okay, we have a sustained finding. Are there levels to excessive force findings? Right. I do think there's something to be said about why group 3, why excessive force only falls under group 3. And, maybe from just a philosophy standpoint, physical force of any kind is kind of it's like the ultimate power of our police department, right? That they're allowed to use when necessary. And I think any violation of that is a major violation of trust and abuse of power, even in a case like this where, obviously there wasn't, a ton of necessarily damage done. But I think from a philosophical standpoint, we have to treat all physical force extremely seriously. Yeah, with that, I'm going to make a motion unless somebody else has something they really strongly want to say. Member Gatton?
I'll just add one thing. As is with any sustained finding, there is a range of disciplines that can be put in. So that can end up and be at the low end. It could end up and it was a termination. If it's a beating with a baseball bat, I would hope that rises to a level of termination. In this case, perhaps it ends up lower. That's for someone else to at least initially decide.
Right. Great point. Okay. With that, I'm going to move that this be treated as a Group 3 violation under excessive force and physical force not within policy.
Second.
Seconded by Member Gatton. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, still got a few more motions. Same case, 2024-0270. This is for allegation B of improper arrest, allegedly in violation of GPO 3.04.01 for officers Joshua Howe, badge number 1190, Officer Russell May, badge number 2129, and Officer Logan Weber, badge number 2425. I move that that these officers be I move for a finding of exonerated as the preponderance of the evidence, including interviews, WCS footage, and written reports, supports a finding that the alleged conduct did occur in that an arrest was made. However, the conduct was carried out in alignment with the standards outlined in our applicable GPOs and manual rules.
Second.
All right, we got a second. Again, this is a motion for exonerated. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. All right, same case 2024-0270. This is for allegation C, unprofessional behavior, unprofessional conduct, allegedly in violation of Manual Rule 5.08, 5.09 for officers Joshua Howe, badge number 1190, and Officer Russell May, badge number 2129. I move for a finding of unfounded as the preponderance of the evidence, including WCS footage, interviews, and written reports, establishes that the alleged conduct did not occur. Again,
second.
Unfounded. Seconded by Member Sharp. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. Okay. I have a discussion on this before I make this motion. And what I'm looking at for reference is that there's also an allegation of unprofessional behavior against Officer Weber, badge number 2425. This is the same officer where we sustained the use of force, the excessive force allegation. And so my question is for our investigator, GM Watson, and it's about the recommendation. Is this recommendation, is the recommendation based on any facts separate from the use of force specifically? Does that question make sense?
The unprofessional behavior was based on his words and what he was saying.
Is it based upon the words?
Yes.
Okay. Wanted to make sure.
It just happened to be simultaneous to the force.
Yep. Okay. I just wanted to ask and make sure because I'm cautious about us making sustained findings of multiple allegations for identical conduct, even if it could technically mean multiple things. So I just wanted to reiterate that. Okay. So does anybody else have any other questions or comments about that? I'm going to make a motion. If not. Okay. Case number 2024-0270 for Officer Logan Weber, badge number 2425, regarding allegation C of unprofessional behavior in alleged violation of Manual Rule 5.08 and 5.09. I move for a finding of sustained, as the preponderance of the evidence, including interviews, WCS footage, and written reports, supports that the alleged conduct did occur, the alleged conduct did occur and was inconsistent with division standards, and in fact violated Manual Rule 5.08 and 5.09.
And Chair, can I add? Oh, yeah, go ahead. You were saying specifically. I was going to say specifically. Go ahead.
No. If you have it ready, you can go ahead, and I'll just accept it.
Specifically, that when she leaned toward him, got in his face, he said that he was going to hit her if she got in his face again. That's the unprofessional behavior.
Yes, so I will accept that, and I will also add the language of, she asks, "Are you about to punch me?" And he says, "If you put your mouth near me again, I will." So even if the situation was that he was trying to imply that, if you put me in danger in some way, then I will respond. That's not what he said. And he basically agreed that he would punch her, which again would be an excessive use of force and therefore improper statement to make toward a complainant that again also was clearly in a highly agitated state. So that certainly was not any sort of de-escalation tactic, and in fact did escalate the situation. So I will add that as well. Does anybody else want to add anything to that motion, to that language, or that rationale? If not, then we will move forward with the motion as put forth, and that would be a motion. It is for a sustained finding. So can I get a second?
Second.
Seconded by Member Sharp. All those in favor say aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, so we need a group level. Does anyone have any recommendations that they'd like to put forward for group level? I'm thinking maybe a group level 2, but I'm looking for specific language.
Group level 2 does have abusive and demeaning language. That was abusive
demeaning
language.
It also has conduct unbecoming, diminishing the esteem of the division. Does anyone else have any thoughts or opinions on that?
No, I think that accurately depicts what we want to say here.
Okay, so I move that this be considered a group 2 violation, and group 2 violation for abusive and demeaning language, as well as conduct unbecoming and conduct that diminishes the esteem of the division.
Second.
Seconded by Member Sharp. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. All right. Still here. Case number 2024-0270 for Officer Weber, badge number 2425, regarding allegation D of property damage in alleged violation of GPO 4.08.01. I move for finding of exonerated, as the preponderance of the evidence, including interviews, WCS footage, and written reports, supports that the alleged conduct did occur. Hold on, what is it? Let me get the exact conduct up. Does anybody have the exact property that was destroyed here?
It was the breaking of the window.
Right. Okay. I don't know why in my head I was thinking about something else. Okay. Yes, the alleged conduct did occur in that the window was broken and therefore the property was damaged. But that this was in furtherance of a proper detainment and ultimately a proper arrest, and therefore it was in alignment with the standards outlined in our GPOs and manual rules. So again, my motion is for exonerated. Take a second.
Second.
Seconded by Member Saganovich. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. All right. Same case 2024-0270 for Officer Sergeant Kevin Walker, badge number 9234. It's for regarding allegation E, improper procedure. I move for a finding of exonerated, as the preponderance of the evidence, including interviews, WCS footage, and written reports, supports that the alleged conduct did occur, but that the conduct was carried out in alignment with the standards outlined in GPO 2.01.06. Again, this is a motion for exonerated. Seconded by Member Sharp. All those in favor say aye. Aye.
Aye.
Any opposed? Any abstentions? That motion carries. All right, last one, 2024-0270 for Officer Logan Weber, badge number 2425, regarding allegation F, the improper procedure for failure to report under GPO 2.01.05. I move for a finding of sustained as the preponderance of the evidence, including WCS footage, interviews, and written reports, supports that the alleged conduct did occur and was inconsistent with division standards in violation of GPO 2.01.05. And specifically, this officer failed to file a use of force report after using force on the complainant, as outlined in our earlier motions. This would have this would have constituted a level of force that did require him to submit a use of force report and did not. So therefore, we are moving forward with a motion for sustained finding.
Got a question, Chair.
Yep.
So the use of, and I should have asked this earlier, the use of force report, the officer who committed the use of force is required to report themselves?
Yes. Yep.
That doesn't seem likely. I mean, I could see it being required of other officers who witnessed it to come forth and file a report, but I'm going to file on myself.
Well, because the idea is that uses of force aren't necessarily negative for the officer. I mean, it's just a fact of something that you had to do, right? And now, if you are doing some use of force that you shouldn't be doing, it's hard to. We can't necessarily just legislate completely around misconduct by officers, right? But generally, the idea is I had to use force on someone. The other officers in this case filed their reports for use of force for themselves, right? So it's not necessarily I'm filing because I know I violated. It's just I use force.
Got it. Okay. That part was lost on me. That just the fact that you had to use force, period, you're supposed to fill out a report to say that he did not. Got it.
Right.
Okay.
It's not an excessive force report. It's just a use of force report.
Use of force. Yeah. Got it. Thank you.
Which, I mean, one could argue that, not filing that report says something about the mental state of the officer or whether or not they thought they should have used that force or not. One could say that. Not saying that we're saying that, but yeah, so we have where were we? Did we get a second?
Need a second.
Seconded by Member Saganovich. Again, this is a motion for a sustained finding for failure to report. All those in favor say aye. Aye. Any opposed? Any abstentions? That motion carries. All right, so we need a group level on this one as well. If anybody has any suggestions, let me know. All I'm thinking that this is probably a
So,
group level.
Under
I
one,
think
you have
failure-
reports failure. Failure to submit reports is under one.
Yeah.
But Chair, I do have a question on this, because you kind of alluded to what was his mindset. Did we ask why he didn't fill out his use of force report? Because you if you are correct, or if you're thinking he didn't do it to cover up his use of force, then I think that's a different group level. But if it was just, I don't know what the reason is, it's something that is okay, then it's something different. So did we find out why he didn't fill out his report?
GM Watson, do you have an answer to that? Did we ask him specifically why he didn't fill out a report? Did he say that, I didn't feel like this was actually force?
That is exactly what he said. Yes, he didn't believe it was a use of force, so he did not do a use of force report.
Then I got a problem with that, because all the other officers didn't do what he did and filled it out. So to me, and this is just me, it seems like he was trying to cover it up. So to me, then that's a different group level than a one.
There were no
But-
use of force reports filed by anyone in.
Oh, there were not.
Correct.
So there were no use of force reports done for the arrest itself?
No. Everyone said it was de minimis for everything, including the sergeant.
Interesting. I don't know that I caught that before.
Without that, I think still it at least rises to a group level one.
Well, certainly, yeah, it's a group level something.
Yeah.
So the idea is that de minimis force does not require reporting. Is that right?
Correct.
Right.
So
Yeah.
aren't we, the use of force here is really when he was holding down her arm and she was complaining about it more so
Right.
than the arrest. We're not dinging him for the arrest because they used whatever they needed. Otherwise we'd have to get them all. But I don't think it was about the arrest. I think it was about afterwards.
Right. Yeah. This is more so focused on the same force that he used that we earlier ruled was excessive.
Right.
But not only the arm, but pushing her head back. I think that was excessive as well. She's already restrained.
Right. I mean, when we made the motion for sustained finding, we included both.
Okay.
That's
All
part
right.
of the conduct. So this would be for both.
I'm saying it was in regards to the report in the, yeah.
Right.
Go ahead.
So yeah. So I think in regards to the report, this would be for reporting both the arm hold that she complained was painful, and also the forehead push. Okay, I move for a group one violation for failure to report. Yeah, and so it'd be failure to report for the force used on complainant in the hospital.
Second.
Seconded by Vice Chair Mountcastle. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. All right, so that concludes that case. And I think that concludes our cases for the day. Is that right?
I had something to add on this
Oh,
case.
yes, Dave. Sorry about that. Yes, Member Gatton.
Thank you. We saw in this video at some point they said, we're going to break the window. And then ultimately when they did, they used the steel baton, stands back, gives it a whack, and glass goes flying everywhere. And I guess one of the things that I think we should, or they should take a look at is, in this case, there were children in the car who we don't know if, glass can fly and hit a kid in the face, the eye, or whatever. And the kids were clearly traumatized. They were screaming. I think they were screaming after this window kind of exploded from the hit. I get that sometimes they need to do that. You know, if there's exigent circumstances where somebody is doing something that, hey, we need to get in there pronto. But for about $15, they can there's a spring-loaded, like little tiny window breaker that you could hold on a window and it hits out a small steel, nozzle that will shatter the window, but glass doesn't go flying everywhere. It just breaks the tempered glass. And then you just push the window in and do what you need to do, which in this case was unlock the car. There's no need at that, from what they did. I mean, they're doing what their procedure is now. But there was really no need for them to stand back and, smash that window open to like, we need immediate access right now because whatever's going on in the car. It really wouldn't have slowed things up much at all in this case. If they had this little thing they could put on there, it goes bang, shatters the window. They could push the window in and do what they need to do. So I think the police ought to have one of these in each one of their cruisers. I know that there are times where they got to bash the window in, but I don't think in most cases they need to. Usually they're bashing the window in because they want to unlock the door to get the person that's refusing to come out. Okay. The car's on fire and they can't get the person. Yeah. Smash the window. But especially in this case where there were children in the back and those little shatterings of glass are going everywhere. I just think that we might forward to the department, I don't know if, or CPC, take a look at this policy. Is there a better way to do that than potentially putting, in this case, innocent children at risk from, flying glass possibly injuring them?
Yeah,
Or the person in the car who's saying, I'm not getting out. Why do we want to create an injury to them?
Member Moore?
Yeah, I was just going to say I totally agree. And I may have misheard, I thought at one point in the video somebody asked if they had that tool. And again, I may have misheard that, but that's exactly what I was thinking. Like, okay, well, why don't they have that? Especially when you're talking about kids in the back seat. So, I don't know what we can do to make that recommendation or forward that to somebody who can make the proper recommendation. But I believe that's something that's a tool that's needed.
Yeah, I think those are great points. And there's a tool that, that literally is made for this. And I've watched other, body cam footage videos just online of officers using those. And I don't, it's not mandated yet, but I think it's something we could certainly ask the CPC to take a look at and make a recommendation. Again, to Dave's point, either requiring that each, maybe a patrol car is suited with one of these window breakers, or that, put something in place where if there are children in the vehicle or there are specific circumstances that increase, the likelihood of people being injured by breaking the glass, and then maybe require a window breaker of some sort. But I do think because it seems to be such a relatively simple fix, I don't think it should be a problem for us to recommend that to the CPC to say, hey, you should take a look at this and see if maybe we should require window breakers.
Do we make a motion for that if we want to? Is that how we proceed? Yep. Okay.
Yep, we can do that. We can ask Jalecia to send over a letter to them.
I'll give it a shot. I make a motion that OPS put together a recommendation correspondence to the CPC regarding looking at using spring-loaded window breakers for getting into cars when it's necessary to break the window. And the policy around that as to when one should be used. And most likely one should not be used unless one needs to be used unless there's exigent circumstances, because the flying glass from hitting it with a baton can injure the occupants of the car, which may be unnecessary.
I second that motion.
I'll add the friendly amendment that we ask our administrative assistant, Jalecia Fair Johnson, to prepare that. So that way it'll come directly from us instead of coming from OPS.
I concur with that, yes.
Okay, now we'll take a second.
All right, I second it now.
All right, with the second, all those in favor of sending this letter over to the CPC, say aye.
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 Any opposed? Any abstentions? That motion carries. All right. Okay, so anything else on this case? All right, hearing none, then we can move to the next portion of our agenda, which is an executive session. So I am going to move for an executive session for personnel, employment, and discipline matters to be considered, and for us to allow in Administrator Michael Hess, General Manager Jessica Watson, and of course our counsel, Dahlia Alprian. And is there anybody else I'm forgetting that we need in here? Jalecia Fair Johnson, our administrative assistant, just in case we need her to come in. And we can invite in Chief Rick Myers as well from the monitoring team. Okay. Anybody else? Anybody? Am I missing anybody?
I think you got them all.
Okay. Hearing nothing. So that's my motion for executive session. We'll need a roll call vote. Chair Brown, aye. Vice Chair Mountcastle,
Aye.
Member Saganovich,
Aye.
Member Gatton,
Aye.
Member Miller,
Aye.
Member Moore,
Aye.
Member Parker III, Member Sharp,
Aye.
Member Willis.
Aye.
All right, the ayes have it, and with that, we will move into executive session. To start, we will just have. Let me pull up. For starters, can we just have the board in, as well as we can have Dahlia in as well as our counsel, and we got Chief Meyer in as well.
Did I miss the link?
Are you using an external email, like the one that's not your CPRB email?
No, I'm using my CPRB. The link normally comes up on the screen. It didn't come up. Oh, there it
It
is. Got
should
it.
come up now.
I got
Okay.
it.
Member Gatton, do you need to be put back into executive session? All right, I'm sending you over now.
You're going to send me a link, correct? Was that Jessica?
I think that was Jalicia, but there should be a pop-up.
Okay. I don't see it yet.
Okay.
It's having issues popping up. I am trying to rectify that right now.
Okay, thank you, Delicia.
It is not allowing me to view the break room, so I am trying to log into my account to see if I can rectify it from the user end. So 1 second. Member Gatton, you should receive the link.
We're back. You're back. 1, 2, 3, 4, 5. Good enough for me. Okay. So thank you for your patience while we were in executive session. We will now move forward to the next part of our agenda, which is the OPS status report. And I will turn things over to our interim administrator, Michael Hess.
Yeah, so a couple of quick updates for you guys. The case intake for January. I know that this says 12 on the list. We actually got 14, and then the 2 administratively dismissed cases were actually from cases that we were investigating from 2014. We found that they were able to be administratively dismissed, so it's not any of the new cases yet that we've determined can be administratively dismissed. So 14 is a little light for a month. So that's interesting. I know a couple of the things that we had been talking about. I guess a primary focus of the OPS leadership here is we're trying to strengthen our relationship with which might call City Hall, the finance department, and the HR department. So I had a great meeting yesterday with the HR director. And so he is going to make a lot of resources available to us that I think is going to, as we've said, kind of try to build a soft landing spot for the new administrator. So I think that's all moving along nicely. The other thing we're working on is kind of building a little bit more of a comprehensive training plan, both for OPS's investigators and for the board. And so we have one of those coming up later this month. If any board members have any suggestions on topics that they would find interesting for training, please shoot me an email and let me know, and we will try to accommodate that if it's possible. I guess the last update for us is there's going to be a call for proposals coming out from NACOL. I think that the call is going to be sent out to everybody this week. And our interim senior investigator, Art Boker, has told me that he is working on a proposal that's going to be for basically kind of social media and how that relates to oversight. So he might be presenting at NACOL. He's at least going to put out a proposal. So I think that would be pretty exciting. I think our last updates, and I'm going to kick it over to Dahlia again for this because our last update is related to one of the cases that we put out to be independently investigated, which I think that you guys might want to discuss in relation to next month's meeting. So Dahlia, do you have an update for us on that?
Yeah, so for case OPS 2025-0046, that report from outside counsel has come in and will be distributed to the board at some point today. And then would be nice to have on the agenda for the 25th meeting so you guys can get a presentation from outside counsel regarding that report. That's my update.
Okay, so that presentation is going to be ready for the 25th, right?
Yes.
Yeah.
It should
So I know that it hadn't been on the agenda, but if you guys were interested in adding just that one case to the agenda for the 25th, that'll be ready to be presented. Well, that's up to you guys. And then the final update from OPS, we do have a quick presentation from our community engagement coordinator, Sam Montanez, who I think is on here as well.
I am.
So if you guys are ready for that, we can get into that.
Wonderful. Good afternoon, everyone. I'm Sam Montanez, of course, Community Engagement Officer. I did have a slide deck ready, and then technology is not always my best friend, even though I'm Gen Z. Doesn't always work out for me, but I do have some things I want to show you guys and give you all some quick updates. So the last time I gave an update, just looking at my notes here, I'm still working on the social media bios and doing that social media rollout. I'm still missing a few, which is why I just haven't done that yet, just so I can make sure I have everyone. I will circle back around to those that I do not have. And of course, we have our new interim and would love to introduce him on our site as well if he would like to. So that's an update about that. This morning, I shared with you all a calendar called the OPS Engagement and Events Calendar. It has been shared to your City of Cleveland emails. There you will find events that either I will be attending or events that I would like for you all to know about. Currently, right now, even just for today, there's a few things going on. Tonight is the 2nd District Policing Committee meeting, which I will be attending at One Hope NEO from 6 o'clock to 7 o'clock. As I mentioned last update, I do encourage you all to attend the meetings that are within your wards and are within your districts. It's really nice to have that presence and for the community to know that we are here, we're involved, and we want to hear and listen to what they have to say. Another update that I do want to show, if I can share my screen, or does anyone have any questions about the event calendar for right now? And if not, you can feel free to reach out to me.
Ms. Montanez, did we make adjustments for the redistricting process to see if any board members are in different districts based on the new map?
I did not do that, but I can look at information and see if anything has changed. I believe everyone is probably still the same, but I will double check on that. Just so we can clarify where folks can go to make sure that they're in their districts. Yeah, absolutely. Let me write that down real quick so I do not forget. Does anyone else have any other questions about the community engagement calendar? Great, thank you. I would just I'm gonna make sure that's updated also on a monthly basis. So right now, everything for Cleveland City Council is up there for committees. And then I will later on add more community events as I find more. With the weather, January was pretty slow. I mean, there were a lot of events, but unfortunately for me, I could not get out of my driveway because I live close to the lake. So there were lots of times I couldn't get places, and a lot of times events were canceled because of the winter storms and stuff. But February is updated so far with at least city council, district policing, and then more community events will be added. And again, that'll be on a monthly basis that I will update that. Now I want to share with you all something we had discussed at my last update as well. We did discuss a meet and greet event or a joint event between CPC and CPRB. I think right now the best course of action would be to pause on that, given that they just got their new executive director formally instated. That would be my recommendation, just so that they can get their bearings. I don't really know who's handling their events over there, if they're even doing any events. So just trying to be cognizant of our neighbors down the street. But in that same breath, I did discuss, it's still a working title. My clinics, my monthly clinics that I think would be really great for the community. So if I can share, Jalicia, could you give me sharing ability or no?
You should be able to share. I'm gonna double check the meeting settings.
Okay, now I can. Okay, so can you all see this tab on my screen?
Yep.
Yes.
Okay. So this is an event or a project proposal that I drafted up that really outlines what I'm thinking for I call it a complaint clinic because it's stuck in my head, but working clinic, anything, we can always change it. So essentially, the objective is to make OPS staff available for citizens to file a complaint or ask questions outside the traditional workday and would occur on a monthly basis. That can always change. The targeted outcomes would be to engage citizens with our office and the board, make filing a complaint and our team more accessible, and greater presence in the community. The budget is zero unless we talk about materials, which we have plenty of materials currently in office. So right now, I'm not factoring that in. Timeline would be, month out, we develop the plan, 3 weeks out, secure a location. Another 3 weeks, confirm the investigator and board attendance. I know you all are very busy, and so I want to make sure I give you ample time to sign up or to let me know that you are willing to join us for this type of event, just to make your presence there. And I know it's probably difficult, though, if people are filing complaints. You probably can't hear that. So if that's a non-negotiable, then you do not have to worry about your attendance at all. 2 weeks out, we'll be sharing on social media, maybe potentially do an email blast. Another 2 weeks out, go the old-fashioned route and hang up flyers and pass them out in community spaces and in events that I attend. A week out, continue all social media, and the day before, compile all necessary materials. Day of, arrive early and set up. Personnel needed would be the community engagement officer, the intake coordinator, 2 to 3 investigators, and if allowed, 2 to 3 board members. Notes that I have is, especially when thinking about any of our events, locations need to be on a bus line, have free parking, look at libraries and our rec centers and other community centers, identify the necessary materials, and also just thinking about something for me to think about is investigators rotating on a monthly basis. So I wanted to show you this all to let you know that I've really thought this out and that I think this is something that we could do potentially in March, just to give people time to coordinate their calendars. I know, again, we've talked about it, but in that conversation, it kind of switched over to the meet and greet and stuff with CPC. Does anyone have any questions or comments, concerns, or suggestions for this clinic?
They face if they raise their price by 2 cents.
You have background noise too coming through. So
Sorry about
thank
that.
you. Yeah, it's okay. But did you have a question?
Yeah, actually I did. Or well, really a comment. For the clinic, I would caution about board members attending because inherently for the purpose of it, people will come up to you and discuss cases and you more than likely would have to recuse yourself because there's a potential not to remain objective. So that unless you had it set up, Ms. Montanez, where the board member was coming in to probably speak at the beginning and then exit before you really got started.
Thank you for that. Yeah, that's a great idea. I think we can work that out that way. Or again, as you had mentioned, just really being cautious of board members attending. Again, it's just more so trying to get you all out there. But again, I understand that process. So I'll think through more of that. If there's any other way that maybe we could do something on a quarterly basis with the board instead of you all coming to the clinics, there's something we can maybe do potentially on a quarterly basis to get you all out in the community and people can come and speak to you all and stuff. So I will make sure to write that down. Sorry, my memory is that of a pea, so I have to write things down very quickly. And so does anyone else have any other questions, comments, or concerns about this clinic potentially for next month?
No, I think this is an excellent idea. Even if the board can't be there, it would be great to have OPS doing this, and let's just make sure as far as logistically that we figure all that stuff out with if you work with Mike and maybe Jessica on that to make sure time wise, since this is a after hours event, let's make sure we're on the up and up about how we're staffing this and what that's going to look like. But I think it's an excellent idea.
Absolutely. So well, thank you. And then also just this fun sidebar about this template. this will also be something that if you all have an idea for an event and you're like, I would like a template, or I mean, I know you all probably have planned events before, but I created this template for our office use. So I'll be sharing this with my team if they have ideas, and I could work on it with you all. I'll work on it with my team if they have ideas. But this is just something for us to keep track of and just kind of have everything written out. And we can always develop it more if you all have better project streamlining tools. But it's something I created that I think really helps map things out and gets all the ideas down. So if you would like a copy of this, please just let me know, or I'll just share it in our general folder. Okay, now the next thing I'm going to share is, there it goes. So this tab right here, hold on, I'm so sorry. Gotta make my screen bigger. This tab right here, can you all see this?
Yes.
Okay. This is the quarterly newsletter that we have discussed before. And so with that, this is kind of just what it'll look like. And I wanted to show you all what we were thinking. We would have an opening and from the administrator or director's remarks, and this is kind of just what would be in that opening. Next, we will go to a quarterly case statistics, internal detail allowed, because again, this is an internal document that will be shared only amongst the board and staff. Then we have the community engagement and outreach update. And these are just compiling, what our impact has been in the last quarter, some key takeaways and community feedback, a summary of our outreach activities, and some upcoming events for the next quarter. And then, of course, internal opportunities for staff. So a lot of the stuff that they do down at City Hall and at the satellite locations. And then this is the final portion, internal updates from GM Watson. They're just operational highlights and processes changes, training and professional development, staff and investigator spotlights. Since this is both shared with the investigators and the board, we'll have, mutual transparency. So summary of the board activity, key decisions or case recommendations, some trends that you all are noticing in the types of cases that are coming, and just reminders for you all as well. So, just clarity of findings, making sure that you have access to all of our documents. I moved that. And then policy reform, internal workflow, administrative updates, etc. So that's kind of more like just the logistics and everything. Looking at this document, it looks very plain right now. I know, I understand that. It'll be updated better. The whole point though is I wanted you to see what type of content will be within there, what we will be discussing, what we will be sending out. The goal, I think now, the initial goal was to have this out in January. I talked with interim administrator Hess yesterday a little bit about that. I think potentially sending this out actually towards the end of the first quarter to give a first quarter overview would be more helpful, just given the delay in this right now. Does anyone have any questions about that? Comments, concerns, things they might want to see in it, things they don't want to see in it, things that we might spend too much time on?
I think it's a great outline. It's always good for us to be able to have reports from OPS. We usually do a status report, but we keep those those are pretty like very high surface level. So like to be able to kind of dive in like this at a regular basis, I think would be very helpful. So thank you for pulling that together. And I do agree. I think starting at the, maybe toward the end of the quarter is a little bit better. Give Mike a chance to be here for a little bit. And then, he'd be able to help out with his portion. And we're implementing some new things at the beginning of this year. So it'll help to kind of get a report on where we are after implementing some of the new initiatives, if you will.
Absolutely.
So yeah.
Any other questions? I know you have been meeting so long, but I just know I can't be that great at my job. No other questions? I mean, maybe I am. So,
I mean, you are pretty good at your job, so I wouldn't doubt
um,
that. And I think maybe we'll have more. I mean, we're at the beginning stages of a lot of this stuff, so I think a lot of
yeah,
times more questions come once we actually start moving on some of this. I mean, this is all very much in the early kind of planning, getting stuff together kind of phase. So I wouldn't take our silence as lack of
no,
engagement.
it's
I
okay.
just think there's a lot being thrown at us, and once we see it kind of in motion, and we're actually doing it, it will have a lot more feedback and things like that as we're getting through it. So we appreciate the work that you're doing though, and how you've hit the ground running, and we're looking forward to getting out there to the community. And
No, I definitely appreciate it. The winter's always hard for community engagement, especially here in Cleveland, just given the weather and things getting
yep,
canceled and stuff. So, as the weather continues to get better, we will see a lot more events, and we'll see a lot more things. I mean, there's still a ton of stuff happening, but just sometimes the accessibility portion of getting to those things is hard for people, given just nature. And then
yep.
another thing I just wanted to highlight is that um, I did get to meet with the new executive director over at the CPC. She's excited to also hit the ground running and would love to have a conversation with the interim administrator. And is also excited for a better partnership between our offices and our teams. So I think it will have a really good partnership. I still encourage board members to reach out to the policy outreach and the accountability committees over at the CPC just so there could be an understanding of what policies they're doing, what things that they're doing to better help you all make greatly informed decisions. Um, and then I still have down my goal that I would love for you all to achieve, which is maybe just one event per quarter out in the community or more, whatever your heart desires, but at least one just to get you all out there. I think it's really important. So, that is pretty much all I have for my update. Those are some of the biggest things that we had talked about last time, and I wanted to make sure I followed up with you all about those again. Um, Again, please check the engagement calendar. If you cannot see it, reach out to me and I'll reshare it with you. Again, that'll be updated on a monthly basis, so you should be able to see that um, when in your calendar, your city calendar, so that way you can go to all the events and know where they're at and stuff. So, and then Board Member Sharp, again, I'll figure out your question about if the redistricting impacted what district now um, folks live in, if their police district has changed due to the wards changing.
All right. Well, thank you very much. I mean, that calendar will be very helpful. I see there's even events going on tonight and the next couple of days. So hopefully board members can start getting the things go into your inbox. You got to click add in order to add the calendar. So don't just go to your calendar and think it's going to be in there. You got to go into your inbox, click it and add it, and then it'll be in there. So once you guys do that, just it's the kind of thing where hopefully at the beginning of the week, you guys can just look and see, hey, is there anything I can make this week? And just let that be a part of your daily kind of check or your weekly, kind of check-ins with however you keep your personal schedule.
And sorry, Chair Brown, not to cut you off, but if there's also events that I think are more pertinent to our work, so like the district policing committee meetings, like potentially ward meetings or anything that has to do with policing in Cleveland, whether it's grassroots or anything like that, that'll be something that I would definitely send reminders out to us. Not that not all events are important for us getting out there into the community and them seeing us, but I know with the scope of work that we do, we always want to try and make sure we're hitting those events that really impact the work that we're trying to accomplish. So I'll be sure to also send out reminders for those types of events specifically.
No, that's great. Good idea. Okay, sounds good. All right. With that, we can now move on to old business. There's a couple things I will give some quick updates on. We still have a few positions that are either out or open, or we're working on filling, including our permanent administrator role. We are still going through those applications. As I think you guys know, we had 176 applications. So again, it takes time to go through, and we're working our way through them. We are still expecting that we will we're keeping our original timeline. I'll put it that way. For now, as if things change, we'll keep the public updated about that. But we are certainly putting a lot of effort into making sure that our process is sound on that front. Same thing with our permanent general manager position. We're now reviewing those applications as well. And we have some investigator positions that have been posted for anybody who's watching, who's looking to apply for those. I think the most recent posting is actually set to expire tomorrow night. So you'll have that time on that. Otherwise, I think that is all I have on old business. Somebody please jump in if I'm forgetting something. Let me know. Okay. So I will now move on to new business, which is actually no, one more thing from old business. We talked about a meeting on February 25th, and originally we talked about having an extra meeting to discuss some cases. Then we changed it based on some changes that are going on at OPS, and we were going to use the 25th as a day of training for the board, in which there wouldn't be a public meeting for that. But in light of some matters that have come up that we want to address in a somewhat timely fashion, we are going to hold a special meeting on the 25th. It'll be starting at 12 noon. We'll be getting an agenda out for that, of course. That'll outline exactly what we're going to cover, but we're expecting that to go about an hour or so. And then from there, we'll go into our training. And so that won't necessarily be a public meeting because it's just training. But we'll start with some board business. So just to let everybody know, we will be having a meeting on February 25th. Okay, so with that, now we'll move on to new business with NACO 2026. So NACO is going to take place in Lexington, Kentucky. And I just had the dates, and Jalecia just told me the dates. So our administrative assistant, Jalecia Fair Johnson, has more information than I do on this. Jalecia, can you just kind of go into where we are with NACO, where we might be with, how early can we start booking? Do we have any information for that? And just generally an update on that. I know we have our administrator talked about Senior Investigator Boker potentially doing a report, which would be, or doing a presentation, which would be great. I think one of the things that we discovered in our past attendance of NACO is that our structure is unique, and we are emboldened with a lot of responsibility. I think more so than pretty much any other oversight body in the country, you could argue. And I think with that, we can bring unique experiences that could hopefully be helpful to the entire landscape. So I'm glad we're getting to start using that in the space. This is only going to be our third year. Well, I won't say only our third year. This will be my third year attending. And so I would love to see the board be able to kind of participate in the culture of NACO in a leadership role, moving forward. So with that, Jalecia, is there anything that you want to update the board on or tell us about? And can you remind us of what those dates were?
So the dates are November 8th through November 12th, 2026. They have not opened up registration or any booking currently. They just notified those are the dates. So there hasn't been any more updates regarding the conference.
Okay, yeah. So November 8th through the 12th, board members want to put that aside on their calendars. I know 2 years ago we actually had good amount of people from OPS attend as well. So I would encourage that as well. Mike, Jessica, if you guys can try to encourage folks to sign up if we can, that they can go as well. I don't know if we have anybody have any questions or anything about NACO. Board members, definitely, block that time off if you can. Because I'd like for as many of us to be as in attendance as possible. We can make it. All right. Any other questions, comments, concerns about NACO? Okay, hearing none. Is there any other, new or old business that any board members want to address or anything that we need to address? Mr. Willis.
Yes, the 25th meeting. It starts at 12. How long will that be?
It's probably going to run from 12 until, well, the meeting itself is going to run, the public part will run hopefully from 12 to 1-ish. And then the training portion will be after that. So really about 2 to 4. And with the training, we can record the trainings too.
Whole thing or?
Oh. Okay. Any other questions?
So it's safe to say that it'll end at 3?
Wait, say it again.
Is it safe to say it will end at 3 or by 3?
The training should end at 12 to 3. I said 2 to 4. 12 to 3 is the total time period. So it should end by 3.
Right.
Sorry about that. Yeah, the whole time period from the board that we should expect to be spending is from 12 to 3.
Okay.
Okay, anything else? Okay, hearing nothing. If there's no other business of the board, then I will entertain a motion to adjourn.
Motion to adjourn.
Second.
All right, we have a motion to adjourn that has been properly seconded. All those in favor say aye.
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 Any opposed? Any abstentions? That motion carries. All right, that brings us to the conclusion of this meeting at 1:54 p.m. Thank you everyone for attending. I gave you an hour and 6 minutes back, so don't say I never did anything for you.
Great job.